everyone, welcome back to another episode of REACHLaw webinars, and today we are going to talk about the Turkey KKDIK lead registration process, and this will be part 3 of 3 webinars in a webinar series of 3, where we are going to talk about this joint registration management part. There's a lot of things covered in this. It's like letter of access, sales, management of the joint registration itself, looking at updates, what's coming after the registration part. And also, we are also going to talk about sanctions a bit. And that is why we have the following experts in the panel. And I have some messages coming up here, but don't worry about that. So, indeed, we have the following presenters, experts here joining. Would Sibel, do you want to go first?
Thank you, Frederik. Hello, my name is Sibel Kılıç. I am working as a director at REACHLaw Türkiye, living in Istanbul, and I am responsible for the team and operations here in Türkiye office. As a background, I am a chemist. In my career, I have been working on REACH since 2013, and now working with the KKDIK since 2017, since the regulation implemented in Türkiye. And welcome, and I hope you enjoy the webinar.
Thank you, Sibel. And next, Olesia. Please, Olesia, go ahead and introduce yourself.
Yes, hello everyone. My name is Olesia Vinterberg. I'm Global Accounts Lead and Legal Advisor at REACHLaw. I've been with the company since 2010 for many years. And in this particular webinar, I'm in my legal hat and we'll be speaking about the sanctions, Russian sanctions in particular, and why they are relevant and important to understand in the context of the KKDIK registration. Thank you.
Thank you, Olesia. And I'm Frederik Johanson. I'm a partner, head of sales at REACHLaw, chemical engineer by background. I have a lot of experience in REACH and REACH-like chemical regulations. That's also, of course, Turkey KKDIK, which is the topic today. So indeed, this is the third and last webinar in this webinar, 3-part webinar series on KKDIK lead registration process. So we had our first part was the lead registrant nomination part, which we had in October already. It's already on YouTube. So if you haven't caught up with that, you can always look at it on our YouTube channel. The same goes for this part 2, where we looked at this data access, dossier development, looked at the provisional registration, lead registration to be more specific, and submission of these lead dossiers. So the provisional lead dossier as well as then the full, I call it the full lead dossier, etc. We did not talk about letter of accesses. We just skimmed on it. That in this part 2 we talked about data access. I will talk a bit more on that during this webinar, and specifically, absolutely more on the letter of access. So indeed, today we are talking about joint registration management. And also, of course, part 2 is available on YouTube, if I didn't already mention that. So indeed, this is the agenda. It looks simple here, but actually this section 4, where we're diving into this joint registration management part, it has several subheadings. But we'll start with the REACHLaw in brief. I'll just give you a very quick recap of the registration process. If you want a longer recap of the registration process, I invite you to have a look at the previous webinar, specifically part 1. I will then also give you a quick summary of what we discussed during this part 2 webinar, just so you know that this transition is now into part 3. So just as a recap, then indeed we'll look at this joint registration management part, which has several subsections, including the sanctions, which is a bit of a bonus, if you will, in this webinar. We'll look at an action plan for lead registrants in Turkey under KKDIK, and this will be part 3, specifically mostly pertaining to this webinar that we are having today. Then we'll conclude with the conclusions and go to questions and answers, and you will find our contact details also at the end. And I forgot to mention that those questions that have been pre-submitted will be covered in this Q&A part first, then we'll take the question from the chat. And we have one question coming over from the previous webinar. If you participated in that, it was pertaining to these sanctions. So we will answer that question, and Olesia will answer that question in the Q&A section. I'm sure she's very happy to answer that question. Anyway, so I'll give you a quick recap of REACHLaw, who we are, what we do, where we operate, before then going into bulk of the presentation. And by the way, if you hear some noise in the background, it's just we have some construction work, never-ending construction work going on here at the office. So don't mind that. So indeed, REACHLaw, what do? We provide support for REACH and REACH-like chemical regulations and product regulations globally. So as you can see on the map, we have offices in several locations where we have these REACH type of regulations. And obviously, today we are talking about Turkey, KKDIK. So we have an office in Istanbul from where Sibel is calling in. And Sibel will indeed also be then answering questions during the Q&A part. So they're very busy in Turkey at the moment for obvious reasons. So I'll just have her help with the Q&A part. Our newest office is in Ukraine for Ukraine REACH purposes. EU REACH related topics we handle from the head office here in Helsinki. In Manchester, we have an office for UK REACH purposes. In Brussels, a small one for mostly EU REACH related topics. Then in India, actually a couple of offices, one in Mumbai and in New Delhi, servicing the Indian market. They don't have an India REACH yet. Maybe one day, who knows? At the moment, there's no progress on that, but there is an India BIS regulation. And if you're wondering what an India BIS regulation or what it is, then I invite you to have a look at our YouTube channel because we have a lot of content on it. It's not a chemical regulation. It has to do with standards and adhering to standards. And then we also have an office in South Korea in Seoul for K-REACH, K-OSHA purposes. And for those of you who don't know yet, as of is it the 15th of May next year, it will be possible to change ORs under K-REACH, which is something which was very difficult and laborsome and costly to do now, but then it will be much better. But that's a topic for a separate webinar to come later on. Indeed, we have, you could say, three business areas that we work on mostly with our clients. Well, mostly we work on the compliance part and more specifically on chemical regulatory compliance. This is the what REACHLaw, the name already implies, but where we do most of the work and our history is there. And today, of course, we're talking about Turkey, KKDIK. But indeed, we do support also these other chemical EU REACH-like chemical regulations globally. So, for example, as the latest newcomer, Ukraine REACH, and we do that through our office in Ukraine, and we have actually people in Ukraine supporting us. So not just doing the work from outside of Ukraine, but actually supporting the economy in Ukraine by having our people in Ukraine, which is unfortunately something that most other cannot say at this point in time. Anyway, we'll focus on Turkey, as said, today. Then we also provide advocacy support for companies who, for example, want to partake in a public consultation and, for example, need support with technical matters, answering questions, argumenting cases for inclusion or exclusion or exemption from certain criteria as part of the legislative process, etc. And sustainability in the sense that we help clients understand what SVHCs entail in their business line in the long run, etc. But as I said, most of our work happens under the compliance part and more specifically chemical compliance, and that is where we are today with Turkey, KKDIK, for example. And speaking of Turkey, KKDIK, we of course provide a full set of services, only representative services through our subsidiary there in Istanbul, so REACHLaw Turkey. We do it all, so from pre-registration to co-registration, lead registration, which will be the topic today, managing lead registration processes, SIEFs, but also then managing consortia where need be for joint registration purposes, safety data sheets, you name it, training, consulting, etc. Well, we do it all. So we are indeed one of the leading only representative service providers worldwide. and now also supporting Ukraine REACH. But as said, today we are talking about Turkey KKDIK. So Turkey REACH, in other words, for those of you who do not know the acronym KKDIK, Turkey REACH, but in the Turkish language. So that's where the REACH is translated into KKDIK. Don't ask me to read the Turkish name of the legislation out loud. I'll leave that to Sibel if she wants to in the Q&A. Anyway, so indeed we have this REACHLaw Talks YouTube channel. I invite you to have a look. We post our webinars and YouTube specific content, and we also make these shorts and AI powered, let's say, podcasts, etc. So now we have 160 videos there already. So I invite you to have a look, and if you like, you can subscribe and give a thumbs up to these videos. And if you, by the way, if you don't know already, you can connect your company email address with a Google account. So you don't have to subscribe or watch these YouTube content, for example, through your own personal Gmail account. You can connect your business email with a Google account, meaning you can then subscribe under that profile for this YouTube content, etc. Just a pro tip there for you. Google how to do that, or use ChatGPT or whatever. It tells you exactly how to connect your existing company email with a Google account. So it's a separate account from your personal account, which I think you want. Anyway, so we specialize in chemical product regulatory compliance, advocacy, and sustainability here at REACHLaw, and that's what we do. And today, indeed, talking about chemical compliance related topics. And just to keep the lawyers happy and Olesia happy, being a lawyer, just the usual disclaimer and copyright. So please just make sure that this presentation is just for general information purposes only and does not substitute proper consulting and having, for example, REACHLaw support you on a one-to-one basis. So any actions you may take based on this presentation is under your own responsibility, remember that, and risk, obviously. So if you want to have specific help, then please reach out to us. We're happy to help. Yeah, and the usual copyright notice, I will just leave it at that. If you can watch this screen on pause on YouTube if you want to knock yourself out. But now, just to conserve a bit of bandwidth for our friends on the other side of the world, I will just terminate my video feed and go into the bulk of the presentation. So indeed, let's have a quick look at the Turkey KKDIK registration process. Just a brief one, because as said, if you want to have a longer version, just go and watch the earlier webinar recordings. So specifically part 1. So indeed, basic requirements: substances that are manufactured in Turkey or imported into Turkey at 1 ton or more need to be pre-registered and registered by the applicable registration deadline. I will show you this in just a couple of slides. So we have this no data, no market, the same that we have in all REACH-like chemical regulations. What that means is if you don't register, provide data, you will not have access to the market. That's what this means. There's no data, no market. And also it applies to authorization and so forth. But in this presentation, we're talking about registrations. So again, all substances, unless specifically exempt, are within the scope of the KKDIK regulation. But then we can also have substances that are specifically under REACH KKDIK, but they are exempt from registration requirements. So these are typically in Annex 4 and 5 mentioned. You know these already: naturally occurring substances and etc. So indeed, just as a recap again, this timeline summary. So this is a bit of an eye chart, but still, just to summarize that we've had these new deadlines, timelines introduced with this new procedures and principles document that was published in August and has become law that you need to comply with when working with and registering substances under KKDIK. So there, for example, it was defined that you had a pre-registration deadline, which has passed already. It was end of October, 31st of October, that is. And then this procedures and principles document also introduced this lead registrant's appointment deadline, which is end of this year, so just coming up in 3 weeks or so, a bit more than 3 weeks. Then we also discussed in the previous webinars, we talked about these provisional registrations, lead registration. We will talk about it in this webinar also, but more from this, let's say, perspective of letter of accesses, issuing letter of accesses for that. So if you want to have a more deep dive, I saw there was a question on that in the pre-submitted questions, so I invite you to have a look at this part 1 and specifically part 2 of this webinar series on YouTube. You will find much more information about the provisional registration requirements there. But nonetheless, the first deadline which is applicable to the registration for lead registrants under this provisional registration requirement is end of March, by which time these leads who have not already submitted the lead registrant dossier, full lead registrant dossier, will have to submit this provisional lead registration by end of March next year. So if you now, before this date, are able to submit a full lead registration dossier, so according to all the requirements, etc., then you do not have to submit the provisional registration. This provisional lead registration, and your member registrants, co-registrants eventually joining that will not have to provisional submit their provisional co-registration by end of September. So please have a look at those. We go in much more detail in those part 1 and part 2 webinars into this. But indeed, these are the new deadlines that were produced in this procedures and processes document that was published on the 12th of August, if I recall. Other than that, we already know the deadlines for the complete, if you will, registration, which is of course end of next year for these higher volume, nastier substances from for example, CMRs 1 to 10, 1 at 1 ton or more, or then it is very toxic to aquatic organisms substances at 100 tons and more. So these are the same that we had for EU REACH, for example, the same criteria, and the same as we have, for example, for UK REACH, etc. Then for 100 to 1,000 tons, deadline is end of 2028, so 31st of December 2028, and then for the smaller tonnage bands 1 to 10, 10 to 100, it's all the way at the end of 31st of December 2030. But indeed, a lot of things will happen by this first registration deadline, and of course, even more will happen as part of these provisional registration deadlines, because for those who need to submit, they have not had their full lead dossier submitted by end of March next year, 2026, will have to do this and do it during next year, whether you are the lead or a co-registrant registering all the way, for example, here or in 28 or 26, you all have to submit your provisional co-registrations by end of September next year, 2026. So this one was slightly wrong in my previous presentation, but now it should be accurate. Just wanted to show you how many months we have left until registration, different registration deadlines. So indeed, pre-registration is passed already. That's like a month ago already, plus a few days. The provisional lead registration deadline is less than 4 months away. So just keep that in mind. Time is flying. Therefore, for those of you who are intending to become lead registrants, now is the time to take up those actions and get things done. Then for the provisional co-registrations, they have not quite 10 months anymore left to prepare and submit their provisional co-registration dossiers, and it should say 6 here, so 2026. This picture seems to be obscuring that, but 2026. Then the first registration deadline, it comes quite quickly after the first provision or this provisional co-registration deadline, so it's less than 13 months away until end of next year, so 36 months to end of 2028 and 60 months until 2030. I'm not so much worried about these 28 and 30, but the 26 one is just around the corner. So the pre-registration deadline indeed was already end of October, but if you missed it, then just a recommendation is just to pre-register as soon as possible and suffer the consequences if there are any. But there is also provisions for late pre-registration. What that means is that if you are placing for the first time a substance in the Turkish market at 1 ton or more, then you should do this late pre-registration within 30 days from this first time placing the substance on the Turkish market. Joint submission concept, very important for the context of this webinar series and also, of course, this webinar we are having today. So here we can have the lead registrant submits the bulk of the core registration data, so meaning Fiskentox, Ecotox information. They can also submit the CSR, chemical safety report, on behalf of all the other registrants, or then if there are no other registrants, if there's only one company that is the going to register substance, then that company becomes automatically the lead registrant. Opt-outs are possible, but in practice it is quite difficult to. I mean, you can do opt-outs, sure. I meant like individual submissions are possible, albeit that it can be quite difficult to manage. Albeit maybe we will see some of those due to sanctions, but we'll talk about that maybe slightly in the Q&A section, and maybe Olesia is also discussing this off the slides in her section. Anyway, we'll look at the registration workflow. This is like a non-consortium approach. What it means is that the lead registrant takes the responsibility to manage the joint submission, provide letter of accesses, manage companies joining the joint submission, etc. In some cases, it could be a consortium doing this, but in these slides, we are always looking at this lead registrant driven. The responsibilities are the same, but of course, legally, it is the lead registrant who has these obligations. So let's look at this registration workflow just as a recap, and also because this will explain a bit where and why we would need also several letter of accesses. Anyway, so you start as a manufacturer, importer, or only a representative of a substance that's not exempted from the registration requirements under Turkey. You submit, you pre-register, and may become a member of the SIEF or pre-SIEF. You can select the lead registrant. These were discussed in webinar 1, this part 1 webinar. So have a look at that one. We will then talk about these SIEF agreements, and to some degree also cost data sharing, definitely cost sharing, and this is happening in this webinar. But once the lead is selected, you should have these also in place. Then the lead starts collecting data, does data gap analysis to understand what data is missing essentially, and tries to hunt that down. And that was discussed in our previous webinar, part 2. Also, data access negotiations and data collection was discussed in this part 2 webinar. We also talked about the provisional lead registration dossier preparation, so what fields needs to be populated, etc. I also have it here briefly in this part 3, just as a recap, because we are talking about this so-called partial letter of access. I'll come back to that in a second. Then the provisional lead registration dossier is submitted to the ministry in Turkey. This was discussed in the previous webinar. Today we are going to talk about this partial letter of access and related calculations for these provisional co-registrants. Partial letter of access issuance to these provisional co-registrants, who then, once that has been done, go themselves through this provisional co-registration process by, of course, purchasing the letter of access, preparing the provisional co-registration dossier, and submitting it to the ministry. So then they are done for with the provisional part, both the lead and the co-regs. But then it continues, obviously. The work continues with this lead registration dossier preparation. This was discussed in the previous webinar. The blue boxes, by the way, is the co-registrant workflow. We will not be covering this in any great detail in this webinar series because we are talking more about the lead registrant work, which is the orange type of boxes here. Also discussed in the previous webinar was the dossier submission to the ministry, how that looks like. We are now talking about these law calculations, or we're not going into how you add up values, but we'll look at the general concepts of law calculations here and issuance of these letter of accesses. But then essentially the lead registrant is done for this purpose. But of course, as we will talk in this webinar, it's not done and dusted completely, because this like EU REACH, it's EU REACH or Turkey KKDIK is not a destination, it's a journey. So keep that in mind. It continues for as long as you are placing chemicals on the Turkish market, and of course as long as the law regulation is in place. But then co-registrants still need to buy this letter of access that was issued for the full registration part. And indeed, in these slides, I have segregated these. In some cases, they could be just one law that is issued earlier to cover as part of the provisional part, both the provisional and the full part. But in these, just to show them, I would say the more complicated case, and probably the most common case, I'm going through this and discussing this as being two letter of accesses. You're not paying double, but you have to split a full law into two sections, essentially, to cover first the provisional part and then later on the full registration part. So indeed, the co-regs, then once they've done the provisional part, submitted that dossier, they can go ahead with the full purchase of the full letter of access. This does not mean it's like a full substance. It can still be an intermediate, but I'm meaning just the full, as in complete registration by the applicable registration deadline. So not the provisional registration. So indeed, co-registrants purchase the letter of access. They prepare the co-registration dossier, the full, if you will, or complete dossier, submit it to ministry, and then they're done. Except that, of course, they also have the obligations to keep things up to date and maintain the dossier, etc. But this is the workflow, and these are the different parts that are covered in different parts of this webinar series. So now I hope you have an understanding of what we are talking about here today, and how or why we are talking about provisional or partial letter of accesses and full letter of accesses. I'll come back to this later on still. So indeed, coming back to the basics, more or less, after the last registration deadline, they will also in Turkey introduce this inquiry procedure, which means that you will first have to inquire. Once that have been accepted by the ministry, you can then go ahead and submit the actual registration, and that you have to have in place before you actually then are able to place a substance on the Turkish market at 1 ton or more. That's requiring a registration. So this is for like new cases where you're placing a substance on the market for the first time after this last deadline. So some statistics in the registration part. So pre-registration still, there's no indicator that we can check what is the current status, but based on, again, industry discussions, authority discussions, etc., we're somewhere on the higher side of 300,000 different pre-registrations being submitted. KKDIK lead registrants that have been nominated, these we see. You can download an Excel file in the KKS system. So from the last webinar, which was actually the 20th of, no, sorry, actually the data was from the 18th of November, so this is correct. We have only received 7 new lead registrant nominations until yesterday. So indeed, total number of lead registrants nominated at the moment is 3,396. submitted lead dossiers, there's no clear statistics that we can see. That's around 2,500 or so, because now there is because the KKS is open, you can now start submitting dossiers. So therefore, this number is slightly higher than what it was in the previous slides in the part 2, for example, or actually part 1. Anyway, the ministry in Turkey is expecting up to 15,000 different substances to be registered. Under EU REACH, there are 23,138 as of end of September, as the latest information shows on the ECHA web pages. So they're expecting like half of the different type of substances, more or less, a bit more than half of the different substances to be registered in Turkey. So you can see that there's quite a lot of mismatch between 15,000 and this number. In like an ideal world, this would be 15,000 by end of this year, but that's not going to happen, of course. Anyway, a lot of lead registrants currently are only representatives representing non-Turkish companies, such as, for example, EU lead registrants, etc. And they're expecting approximately 50,000 different co-registrations to be submitted. So it's the total number of registrations would be this plus then the whatever this number is later on. Anyway, around 10,000 different companies are affected by the KKDIK regulation, and actually that's an estimate by the ministry, if I recall. All right, let's have a quick summary of part 2 webinar before going into the crux of this webinar, part 3. So part 2, indeed, we looked at these data access dossier developments, etc. So just wanted to highlight that this is not specifically, of course, the first sentence there is not specifically related to the first one, but all of these. So indeed, due to these procedures and principles being published in August, we got clarity on these deadlines for nomination and pre-registration, and then these provisional registration deadlines, etc. So that kickstarted essentially the lead registration work again, and specifically now that the KKS is also open, it's possible to actually submit these lead registration dossiers. So when you are now scrambling for becoming the lead and working on this lead registration dossiers, then we recommend you start with this provisional lead registration sections in the KKS, because those you will need first, and you can just prepare and submit those in your provisional lead registration dossier by end of March next year. And then, of course, when you submit the final full, I call it the full lead registration dossier by the applicable registration deadline, so end of 26 or end of 28 or end of 30, then we recommend you submit these at least 6 months before the deadline, simply so that the member registrants will have enough time to purchase a letter of access, prepare their dossier, submit the dossier, and get those accepted by the ministry. And then start the joint registration work as soon as possible, because it will take time. I've said this in every webinar for many years, and I've just increased that over time, and I'm still saying it. So I think you know this already. But if you don't have a lead for your substance in Turkey, now is the time to step up and become a lead registrant yourself. You can later on, if needed, you can change lead registrant, but at least get it now over and done with, and do this provisional registration. Of course, if your deadline is end of next year, then you will likely remain as the lead also for the full dossier. But it is possible to change lead also later on if for whatever reason you just don't want to be lead anymore. You just wanted to get the ball rolling, so to speak. But indeed, I invite you to have a look at the part 2 webinar on our REACHLaw Talks YouTube channel for details on that. So indeed, What does it mean? You need to start now with becoming the lead for the substances that do not have a lead, and you want to continue placing on the Turkish market, and start with preparing this provisional lead registration. It is very clear. So indeed, now let's look at the joint registration management part. So I'll give you the quick overview. I think you've seen this already. So the blue bits we will cover today. I mentioned those already verbally, but we'll look at the SIEF agreement. We'll not go into clauses, but we'll look at it, what it means, how it functions, etc. We'll look at partial letter of access sales. We look at the full letter of access sales, general communications and updates on updates, etc. We'll cover partial letter of access sales. We'll cover the full letter of access sales. We'll cover joint registration management, so what that means, and lead dossier maintenance related topics. So the blue ones are the ones we are covering. The rest we've discussed. We are not covering the red ones in any great detail, except for the sale of the partial letter of access. We will likely have in the spring or winter time, we will have a separate webinar where we will look at this in more detail, as the provisional co-registration timeline is coming close. So indeed, joint registration management. So what we mean here is essentially the time after you submitted the provisional and full registration dossier. After provisional, you have slightly different obligations. Whilst then, once you've submitted the full, it goes more into the maintenance and management mode. So indeed, after you submitted the joint submission, the lead registration dossier as part of the joint submission, and as long as the joint submission exists, then you have a legal obligation to cooperate for the benefit of the joint submission, meaning you need to keep active in keeping it and maintaining this joint submission, keeping it up to date, and admitting new companies into the joint submission through this SIEF agreement, letter of access, purchase processes, etc. But generally, on a 20,000 foot or 10,000 meter, let's say, view, the process is essentially that you're managing the dossier updates. You continue with the cost sharing plan. We'll talk about this here also a bit more, including the reimbursement part, and you reserve funds for upcoming costs. This is very important to also take care of, because there will be updates and those need to be funded somehow. And according to the law, it is the joint submission, you are sharing in the costs. So that means that everyone who has registered the substance will need to share also in the future costs, not just buying this letter of access now and thinking it's over forever. No, that's not the way it works, unfortunately. Then coordinate and responses with authorities on regulatory matters. Maybe they have some comments on substance evaluation, dossier evaluation, etc. You need to also be aware and manage changes to coming to the dossier, to the users, compositions, classifications, etc. And also changes in the pool of co-registrants. Some maybe there will be latecomers, new registrants, etc. If you leave, of course, you will not be reimbursed, but you will not, if you deactivate, then you will not need to share in future costs, because essentially you are out of the joint submission. So typical administrative activities of the lead registration are, of course, this partial or full letter of access sales. We'll talk about this in more detail soon, after the sanctions part, which is coming next, if I recall. Also the general data sharing related communications and all the related cost sharing issues, topics, reimbursements, funding, future funding, etc. There are also general communications on the status of different things, maybe updates or legal regulatory developments. It's coming there later on also. ongoing cost itemization, meaning that all the costs that you accrue and assign to the joint submission need to be itemized so that you can show transparently where, for example, the costs have come from and where in the future new costs have come from. So it's an ongoing process. Also, of course, manage this data sharing and cost sharing, so do reimbursements calculations and take care of the payment part, which sounds simple, but it can be quite tedious and difficult, depending also. And an added complexity is the if you have payments in multiple currencies, especially in currencies that are devaluing quickly. I think you know which currencies I'm talking about. Communication, of course, with the authorities and these industry associations, maybe this Chamber of Commerce, for example, if they have something to say, because they are working together with the ministry and coordinating different things and advising, I think would be the proper word, advising ministry on topics. General reporting to the SIEF, of course, progress updates. Then you also need to manage the financials. It relates to this cost management and reimbursements, cost allocations, future funding, etc. And then the sanctions. And this is it's not new per se, but it will be new for many companies who are now dealing with KKDIK. So this is something that we deal with here at REACHLaw, and everyone should deal with, that it applies to. So Olesia will talk about this, as said, but also regulatory development. I'll have some slides at the end, what type of things they could be looking at, the lead registrant, because the lead generally needs to know where the regulation is going. Are there substances coming up for authorization included in the candidate list, or additional restrictions added? So these need to be taken care of also in the joint registration, obviously, to some degree at least. And very important, record keeping, 10 years. You need to keep this information up, not up to date, but I mean, have a record of all communication, all related information for 10 years. It's a legal requirement. And this continues as long as you are the lead. So it is this statement that KKDIK registration, or KKDIK in general, is not a destination, it's a journey. So you have embarked on this journey. Now you have to live with it for as long as you are placing chemicals on the Turkish market that are needing to be covered by registrations. So indeed, this regulatory monitoring here, very important to check that your substances, are they coming upon on different lists, candidate lists, authorization lists, or recommendations for included into the authorization list. This hasn't started yet in Turkey, but it will at some point. I think they, of course, will look at what's happening with the REACH review here in the EU and probably adopt some sort of a similar process, but that remains to be determined. But still follow legislative developments, these different substance lists, etc. Follow compliance checks, testing proposals. When the ministry is evaluating these testing proposals, if there are any. Of course, in Turkey, hopefully you would not have to do any additional tests, but if you would, then you need to manage and review those also and monitor. Check the evaluation processes pertaining to the substance itself. Of course, these are all interlinked, but still, let's see if there are new hazards coming up that are relevant for the substance, because these will need to be considered in the lead registration dossier. Updates need to be done in most cases. Also changes to the classification labeling, and then as mentioned, these specific lists and restrictions on manufacturing, placing on the market, or use of the substance. These are things you have to keep in mind and monitor as you're the lead registrant and managing this joint registration. So indeed, we'll look at in the subsections, next subsection, some of these activities, and now I will hand over the word to Olesia to talk about sanctions management. So tell me, Olesia, when to change slides. Go ahead.
Yes, thank you. So let's talk about sanctions management and how they are interlinked with the KKDIK lead registration and registration in general. Next slide. I'm not sure how much of a bonus it is, and maybe sanctions would be the last thing that I would at least imagine when I think about bonuses. So maybe sanctions are not the first thing that comes to mind, but unfortunately or fortunately, this is a relevant topic for the KKDIK registration. And we will try to explain in simple words here, why is this relevant and how can you manage compliance? So a little bit of the background. So the EU sanctions on Russia began quite a long time ago, actually already in 2014 with the annexation of Crimean island. But the major and extensive sanctions regime, as we all know and talk about now, it happened in 2022 with the full-scale invasion of Russia into Ukraine. So since then, European Union has adopted 19 sanctions packages, so quite many different sanctions regimes related to Russia. And on the last bullet here, you can see a link to the timeline. I think you cannot access the links here, so if you want, I can share with you separately, so just drop me an email. I'm happy to share the links. So how the sanctions process works in general. So who adopts the sanctions regulation? So it's the European Council. They adopt the Council regulations, which are the sanctions regulations. And the member states in the EU, they are responsible for the enforcement of the sanctions regulations on their own territory. And the European Commission supports and oversees the implementation of sanctions and provides guidance and, for example, Q&A documents that we will talk about today as well. And when we talk about the Russian sanctions in terms of the European Union sanctions, we usually mean the Council Regulation 269, which is the regulation that lists individuals and entities that are sanctioned, and the Council Regulation 833, which introduces like broader sectoral measures, including the infamous Article 5AA, which is referring to the state-owned and controlled companies, and Article 5N, that amongst everything else bans consulting services for Russia-based companies. So for everyone who worked with Russian companies before sanctions, or is in any case related to the data purchases in the EU or other regulations, they know about this Article 5AA and Article 5N in this regulation. So the EU Commission has published an extensive Q&A document on sanctions. It has very many pages, don't recall how many, but over a few hundreds at least, covering general questions and a lot of sectoral questions. And what's interesting is that they have included a separate section in this Q&A document, the link we will share together with the recording, but it's also on this slide. There is a section 11 specifically on chemicals that provides information on how the sanctions regulations in the EU are interconnected with the EU REACH regulation. So briefly, the sanctions regulations are so-called lex specialis, which means that this is a special law and it comes first. So the EU REACH regulation continues to apply as a general law, but it cannot override or contradict to the sanctions regulation. So this is how it's treated. And we have to always remember when we talk about the EU REACH, we have to remember that we need to take into account sanctions. And in general, the Q&A document has about 15 pages on questions related to REACH regulation and sanctions. So if you haven't seen this before, I encourage you to read those pages. It provides quite a lot of useful information. The whole Q&A document in general, but specifically these 15 pages on REACH and sanctions. We can go to the next slide. So you would probably ask me now, why am I talking about the EU REACH and EU sanctions, and how is this relevant for the KKDIK? It is relevant. It has a direct relevance, in fact. So the EU sanctions regulations, so the scope of the regulation 269 and 833, talks about that any legal person, entity, or body inside or outside the territory of the European Union, which is incorporated or constituted under the law of the member state, is in scope of those regulations. So Article 17 of Regulation 269 and Article 13 of the Regulation 833, they are almost identical. So this is why even if the company is operating outside of Turkey, but it is linked to the European entity, it has to comply with the EU sanctions regulations. So let me provide you an example. For example, in the joint registration agreement between the lead registrant in Turkey and the co-registrant in Turkey, there could be Turkish subsidiaries of the EU manufacturers as the lead registrants, or it could be an EU based on the representative in Turkey. So both of these cases, they have a direct obligation to comply with the sanctions regulations because they are linked to the European Union, and hence they need to comply with the EU legislation, and sanctions regulations are one of those regulations that they simply need to comply even while they are operating in Turkey, so outside of the European Union. And according to the EU sanctions regulations and the Q&A document by the Commission, the provision of data, licensing the data under the EU REACH regulation is forbidden to do to the sanctioned entities. So again, you would ask probably, why is this relevant for the KKDIK? And the answer here is again a direct relevance, because a lot of data is coming from the European Union. A lot of data owners are EU-based companies, EU REACH consortia, EU study owners, EU-based lead registrants with subsidiaries in Turkey. So all of them are obligated by the EU regulations to comply with the sanctions regulations. Next slide, please. So this is indeed a so-called cross-jurisdictional complexity where even though in Turkey there is no sanctions regime against Russia, but companies that are based in the European Union or linked to the European Union yet operate in Turkey have to still comply with the sanctions regulations coming from the European Union. Next slide, please. So now that we know what do we need to comply with and why, let's look at the due diligence and industry best practice. So how do you handle the compliance? So according to the EU sanctions regulations, the compliance with sanctions is so-called obligation of result. So what does it mean? It means that you must not make any funds or economic resources available to sanctioned persons, and this is a strict obligation, period. So you just simply cannot invoke a protection that you didn't know, or claim that you did your best efforts but still something didn't work out. So this is not a light obligation, this is obligation of result, and it's not enough to show your best efforts. You really need to prevent any economic resources or funds to be made available to the sanctioned entities. So under the sanctions regulation, there is an Article 10 saying that in case you really didn't know and had no reasonable cause to suspect that you are infringing any measures under the sanctions regulation, the liability cannot be invoked on you. But in the guidance document by the EU Commission, it was clearly explained that you cannot invoke such protection if you fail to simply show that you did appropriate checks and the inspections. And this is actually coming from the section 2 of the Q&A document of the Commission, in particular question and answer number 10. So read it carefully, because there are quite a lot of explanation on the simplicity of inspections, which are not really simple. So they want you to do quite a lot of things in a simple inspection. But again, in the guidance document, they explain, so the compliance has to be organized through appropriate due diligence process that is calibrated according to the specifications of your business and related risk exposure. We can go to the next slide. In the Q&A document specifically for chemicals and REACH, the Commission elaborates a little bit more what they think about in terms of proper due diligence. So they talk about the contractual clauses, basically agreeing with your counterpart that they will not breach sanctions. So first is the contract clause, or requesting from the counterpart a so-called declaration that this counterpart is not listed or subject to sanctions whatsoever. So that would be like a second thing they suggest. At the same time, if you read carefully this question answer number 8 in the section 11 on chemicals, Commission elaborates further that you cannot simply rely on the declaration given on a contract clause. You still need to do your own verifications. But what it means in practice, let's say you receive the declaration from your counterpart, let's say from a co-registrant, that they are not sanctioned. And the declaration is signed by a company that is listed in the Annex 19 of the Regulation 833, that Article 5AA I was talking about. So you simply know it's there, and you accept the declaration that the sanctioned entity tells you that they are not sanctioned. So this is something that is absolutely not going to work. So you need to have an accurate and well-structured due diligence program, and not simply rely on the declaration, but also use common sense and go beyond the best effort, because this is again an obligation of result, as we discussed previously. Next slide, please. So what do you actually can do in practice, and what industry is doing in the EU and already even in the KKDIK? So let's look at the examples of compliance. In both EU REACH and KKDIK, the sanctions compliance is embedded into the registration process, and we have seen a few scenarios how the compliance is managed. First example would be a use of sanctions clauses in the joint registration agreements or data sharing agreements, and we will show an example of such clause for KKDIK specifically. Then data owners, lead registrant, and substance consortia ask for sanctions compliance declarations or certificates. So it could be that they would ask an only representative, if there is an only representative or registrant, to sign that certificate. In case of only representative, in some cases, the lead registrant would request both on the representative and the represented company to sign, so 2 signatures. In other cases, only the represented company is required to sign. And in some more rare cases, but we have seen that in practice, the lead registrant or data owner, before they sell the data to the co-registrant, they ask for provision of the actual beneficial owners data, and then they do the subsequent screening of these beneficial owners against the sanctions regulations to really see that the entity is not sanctioned, because there are percentages you can apply, and then the control aspect of if the entity is sanctioned or not, so you can do a deeper analysis. But this number 4 is very rare, and we have seen it only in a few cases in our experience. So most of the companies work on the contract clauses and some sort of declarations or certificates of sanctions compliance that they would ask for the represented company to sign, and the only representative to sign, or registrant to sign, and there is no only representation concept. Some companies also use sanctions screening tools, specific tools that you could check the company separately, but those tools are quite limited, not so easy to use, and still normally the more frequent cases are the declarations as such. And the most complicated screening for sanctions would be just that the data owner or a lead registrant would simply screen in a dedicated software through the company name, find the beneficial owners through the beneficial owners registers, and then screen each beneficial owner in the sanction screening tool, or manually through all the sanctions lists of sanctioned persons and entities. So this would be the most extensive due diligence in this respect. But why are we doing this? Basically, we want to protect, lead registrants want to protect themselves, data owners want to protect themselves, and only representatives, of course, want to protect themselves, and no one wants to violate the EU sanctions regulations. In practice, when the data owners in the EU, they sublicense their data to KKDIK lead registrant through a data license agreement, they also often request that the KKDIK lead registrant includes the same sanctions clauses into the KKDIK Turkish joint registration agreement. And this is why you see those clauses sometimes appearing in the joint registration agreement in Turkey. Next slide, please. So let's look at the examples of those different scenarios that we have mentioned. And this would be the scenario number one, where the lead registrant in Turkey would include the sanctions compliance clauses in its joint registration agreement or SIEF agreement, whatever you call it, in the KKDIK. So here you can see more of extensive compliance. So it doesn't only include the European Union sanctions, but also US, UK, and other applicable sanctions. And this is done exactly for the same reason, because this lead registrant might have operations in all of these jurisdictions. And because it is linked to all of those jurisdictions, it has to make sure that it's compliant with all of the sanctions regulations to ensure group-wide compliance. So this is why you see all of this sanctions regulations and jurisdictions in a Turkish agreement for the country that doesn't have a sanctions regime. And I would like to highlight here that in this specific sanctions compliance clause, the lead registrant asks from the, in case of only representative, from both the only representative and the company that it represents, to be sure that they are not sanctioned or owned or controlled by a sanctioned entity. So this is highlighted here specifically so that for the Turkish scenario, the only representatives in Turkey understand that they need to ensure that the company they represent, coming from non-Turkish territory, is also not under sanctions, not only the OR itself, but also the represented company. And in this particular scenario, we can see that the lead registrant also includes a shorter but similar certification, even in the signature part of the agreement, in the caps lock. So again, to emphasize the necessity for verify, are you really not sanctioned? And then you can sign this agreement. If you are unsure, you need to do your own checks and see if you can sign this agreement, because the agreement is anyway conditional to the fact that the counterpart signing this agreement is not under sanctions. Next slide, please. Here you can see some other examples that we discussed. So the compliance certificates, certifying your compliance with sanctions. On the left side, it's the concave substance consortia certification system, where before you purchase the data, nowadays or now they ask to resign this certificate, if I remember correctly, every 6 months. They would ask the EU registrant to verify and certify that they are not a sanctioned entity, asking about the origin of the company, etc., etc. And likely the same process will be also applicable for the KKDIK. On the right side here, you can see an actual KKDIK example. This is These are the clauses coming from the data license agreement that from one of the EU consortia where the data owner licenses the data to the KKDIK lead registrant that will also sublicense data to the co-registrants in Turkey. And this agreement again is conditional to the fact that the lead registrant in Turkey has to implement all of these clauses into its own KKDIK joint registration agreement and make sure that these clauses are understood by the co-registrants. So this is why, again, one of the reasons why you see those EU sanctions compliance clauses or UK sanctions compliance clauses in your Turkish agreements. This is because the lead registrant or data owners in the EU request, well, actually not request, require the lead registrant in Turkey to incorporate those clauses in the Turkish agreements. Next slide, please. To conclude this very complex compliance section, I want to emphasize that the sanctions compliance is the obligation of result, meaning that it has to go beyond best effort standard, and you actually must ensure that no funds or economic resources are made available to sanctioned persons, and the EU REACH data or whatever data is considered an economic potential and economic resource. Therefore, we cannot sublicense or license the data to potentially sanctioned entities. And the robust and well-documented due diligence processes are simply a requirement to ensure compliance with sanctions. However, we need to also remember that according to the EU treaty, there is a principle of proportionality. So yes, the compliance programs and due diligence programs have to be robust and well-documented, but they cannot be unproportional according to the main treaty of the European Union. So just keep that in mind as well. Next slide, please. Therefore, don't be surprised when you see the sanctions clauses in your KKDIK SIEF joint registration agreement or data sharing agreements. If the data is EU linked or the lead registrant is linked to the European Union, for example, a subsidiary of the EU company, these clauses are simply a legal requirement. They are not optional, and they are simply mandatory due diligence that need to prevent circumvention of sanctions. So a company, a subsidiary of the European company in Turkey still needs to comply with the sanctions regulations, and the sanctions compliance cannot be circumvented simply through a subsidiary of an EU company that is located outside of the European Union or in the regime that doesn't have sanctions compliance problems. So fortunately or unfortunately, sanctions have become part of the standard registration process in the EU, and now they will also become a standard part of the process in the KKDIK agreements. So this was a very short introduction to sanctions and their relevance, and please feel free to send me questions on this. I would be happy to answer those. Thank you.
Thank you, Olesia. And REACHLaw Short is actually a webinar in its entirety for most other folks. But anyway, indeed, thank you very much, Olesia. Very interesting, and I hope you found this also very interesting section, this additional bonus, albeit maybe not bonus is the best word to describe it. So let's soldier on. Let's look at this letter of access sales and related considerations for both partial and this full letter of access. Now, you know, sanctions need to be considered in the SIEF agreement or joint registration agreement. It can have different names, but they all stipulate the same things more or less. So, but that was the sanctions. I will not go into those in any more detail. We'll talk about them in the Q&A section. And yeah, I can already tell you that we are going over the 90 minutes. No big surprise there, I suspect, for most of you who attended REACHLaw webinars. So indeed, to join a joint submission, each registrant must obtain then legitimate access to the information that is included in the lead registration that the lead has submitted. So meaning this is typically tox, ecotox, FUSCEM data that usually has been purchased from EU-REACH consortia, EU-REACH lead registrants, or related data holders. And to get access to this joint submission, the lead registrant or consortium, but in these slides we are looking at it from a lead registrant perspective, so they issue this letter of access for companies wishing to join this joint submission in 2 phases in these presentations. So one for the provisional co-registration and then for the final one. And all of this issuance needs to be under fair, transparent, non-discriminatory conditions. And therein lies a slight contradiction with, of course, EU sanctions being and this non-discriminatory. But that's a topic for later. So indeed, we are looking at these 2 things: the provisional or partial letter of access, as I call it, for the provisional co-registration part, and the full letter of access, or LOA, as it's written in the presentation, for the most part, for the actual co-registration by the actual registration deadlines, meaning end of 26, end of 28, end of 30, depending on the substance hazards and the annual volumes thereof. So in some cases, it may, as I already alluded to earlier, it could be that in some cases there is just one letter of access that covers both the provisional and the full part, or there could be maybe some cases where, for whatever reason, the information that's needed in the provisional lead registration dossier and then needed for the co-registration part is, for whatever reason, issued for free. But those are issues we are not looking at today. We are looking at having this letter of access split on a top level like this. They can be further split, as we will discuss here in this presentation. So this will be the longest section. After that, we have a few shorter sections and then we go to the conclusions, Q&A. So anyway, this will take a bit of time, so buckle in. So looking at the basics of these letter of access sales. So to join a joint submission, as said, each co-registrant must then obtain this legitimate access to the data that is referred to in the joint submission, so in the lead registration dossier. So this means that whoever owns the actual study that is referred to in the lead dossier, they have the intellectual property rights for this information, and therefore this needs to be considered when you are joining the joint submission for the provisional co-registration part, but also when you are then, and more specifically, when you are registering for the full registration later on by the applicable registration deadlines. And you must provide this letter of access and access to the joint submission if they have provided then compensation for this information and the work included. So the letter of access is generally have 2, and it comes a bit later, but let me just highlight it here, that you pay for data in the letter of access, but you also pay for the work that the lead registrant is undertaking to take up the lead registrant role and coordinating the work and preparing and submitting the dossier, etc. So both data and work, and all of this has to be under fair, transparent, non-discriminatory conditions, as is written in the law itself. So the most common mechanism for sharing this is the letter of access. There are other mechanisms. For example, you could have a consortium, and if you become a consortium member, you will get access. But the most common way of doing this is for the lead registrant or consortium, but we'll talk about lead registrant driven joint submission here. Then in those cases, the lead registrant issues this letter of access against a fee, and then of course they have to sign the related agreements, so SIEF or joint registration submission agreement, or whatever it's called, cooperation agreement, etc. They are all the same. I'll just call it the SIEF agreement here to keep it simple. These this letter of access, it's a term, it's a general term, but become very common, for example, under EU REACH, and now also being used in other jurisdictions for REACH, like chemical regulations. And just says that it's a mechanism for and an agreement for the sharing of data and the costs related therefore, and granting the right to refer to data in the data that is the rights have been purchased for. So essentially, all these laws do is they do not grant you. I mean, there could be technically maybe some letter of access do that, but I would say in 99.999% of cases, what the law is doing is not granting you ownership right to the data. It just grants you right to refer to the data. So what that means is that you cannot use this data for any other purposes than for your specific, for example, KKDIK provisional co-registration or KKDIK full registration down the line. Usually these letter of accesses are bilingual, the agreements thereof, so you have both in Turkish and in English due to obvious reasons. So indeed, I will not recap this provisional registration. I invite you to have a look at it. I've already touched upon it in the previous slide, so I will just keep it at that, just to highlight that indeed this registration process is now split into essentially two parts. We start with the provisional registration part and then register by the applicable registration deadline with the full registration part, so to speak. And this provisional registration is also split into two, so that the lead registrant first has to submit by end of March next year the provisional lead registration, and then the co-registrants need to submit by end of September their provisional co-registration. And this, when you submit these, you will have to pay the registration fee. It will not be payable later on when you do the proper or full registration down the line. But I just wanted to highlight here what data is included in this provisional lead registration dossier. This was already shown in this webinar series part 2, but here just reiterating and showing specifically that this here, most of these endpoints or this data that you see here, usually these are available at the client or derived from the data included in the physical or chemical properties part, meaning the Annex 7. So essentially the data that usually comes with a price tag is under here, under Annex 7. So because now you're asking, why should I buy a letter of access for the provisional part? Well, the reason is because we need this specific Annex 7 data already in the provisional lead registration dossier. So meaning it's part of the joint submission. For you to take part in the joint submission, you have to compensate against this cost, this data, so that you abide by the requirements of the KKDIK regulation. And that is where you have to buy. Highly likely the way forward is that you need to buy this partial letter of access, covering this specifically this provisional part. And this slide just goes to show what endpoints need to be covered specifically in this provisional lead registration. Of course, not all endpoints apply to all substances, but this is just a list of these, and just to show that already a long time ago, I think it was 2014, there was there was publication made with some generic testing costs to satisfy these different endpoints, starting with the melting, freezing point, boiling point, vapor pressure, flash point, oxidizing properties, etc. So if you just take all of these as euros, these are euros, and you sum them together, we're talking about around 25,000 euros, and probably a much more, because it's already over 10 years ago, so inflation alone would be quite significant. So let's say it would be easily over probably 35,000 if you would have to do those tests. So in effect, the lead registrant will not do new tests. They can, but they don't have to, because this information is also available from the EU lead registrants or consortium. So what they do is they buy this information, include it in the provisional lead registration dossier, and this here will be the shareable data part. On top of that, of course, as part of this partial letter of access, the lead registrant will also ask you to pay for the work that they are doing in taking care of this joint submission, taking care of a joint provisional lead registration, managing this joint submission for the purpose of then registering or provisionally registering the substance in this case. So data is not free of charge, and that's why you will already need to buy a letter of access as part of this provisional registration step in most cases, let's put it this way, in one way or another. So it will not be free of charge, and that's why you need to purchase letter of access, because this is data that is under IPR protection and is purchased typically from EU REACH data holders or applicable consortia. It could be also from non-EU, that's fine, but still those have the same IPR protection interests, so they will not give you they will not give you this for free. There are no free lunches, I'm afraid. So when you plan for your KKDIK lead registration work, then you should start with trying to get at least those endpoints covered, so you know what those will cost that we looked at in the previous slides, so that you can know what the data costs are, and you will likely also know what the cost of work has been to prepare that provisional lead registration dossier that's on behalf of the joint submission, so you can also define those costs in the letter of access. Now I'm taking a few side steps here just to highlight that indeed we have these different EU REACH like chemical regulations. I've not included Ukraine here, still it will come here, but there are these EU REACH, UK REACH, Turkey KKDIK. Of course, UK REACH is going a bit of its own way forward, but all of these have these same data and cost sharing type of mechanisms under fair, transparent, and non-discriminatory conditions, and these data and cost sharing regulations or then guidance or different governance procedures for doing essentially the same thing. So therefore, now you're asking, well, can we have like, and I know maybe some of you are asking, well, if we have this data from the EU and it's 12 years and older, because we have this 12-year rule under EU REACH, we have it under UK REACH, we have it in the Turkey KKDIK regulation also. It means that these study summaries or robust study summaries that were submitted under these regulations 12 years ago or longer time ago would be then made free of charge for those who need to join a co-registration, so meaning they would not have to pay for that specific data in the joint registration. So the 12-year timeline starts ticking when you submit the dossier, and if you then do an update, new studies, then when you submit your update dossier, then that 12-year clock will start ticking again. But the thing is, this 12-year rule, of course, it only applies to data. The registrants still need to pay for the work performed under the provisional KKDIK registration or the full registration later on. But the 12-year rule does not apply between different legal jurisdictions. So the 12-year rule only applies within each jurisdiction in isolation. So for example, now we have registrations that were submitted over 12 years ago here in the EU. So if you now in the EU would register a substance and you would have to refer to data that was submitted over 12 years ago, that data would not cost you anything. But if I buy that same data for Turkish purposes, for Turkey KKDIK purposes, the 12-year rule does not apply in my case. It only applies when I have included it in my lead registration dossier, submitted it, And then from that point in time, 12-year rules, the 12-year clock starts ticking. That means that for example, if we're looking at this part here, I have a comparison between different 12-year rules in the different legal regimes. I will not go into details, but now, for example, if I now in June next year submit this data under Turkey, it means that only in June 2038 would it be free of charge for new co-registrants joining the joint submission under KKDIK. So the 12-year rule does not apply between jurisdictions, only inside jurisdictions in isolation. Very important to understand this 12-year rule in that perspective. I think most of you know this, but we do tend to get these questions quite a lot. So I wanted to reiterate that here. So data sharing under Turkey, KKDIK, Turkey doesn't have a specific data sharing regulation like the implementation regulation here in the EU under EU REACH, this 2016/9 on joint submission of data and data sharing. This came back into force in 2016 in the EU, but they do have this procedures and principles guidance document that touch upon a bit, but they specifically have this data sharing guidance, which you will see a screenshot here. It's essentially the same that we have under ECA. It's essentially the ECA guidance document that has been translated into Turkish with only minor modifications to fit the Turkey KKDIK regulation. So what that means is that regardless, even though there's no data sharing regulation specifically in Turkey, the same rules apply. So what that means is that as a lead registrant, you need to itemize all your data, all your costs, all your administrative work, etc., for both the provisional part and the full registration part, and document everything, including the cost sharing model, the reimbursement mechanisms, future costs, etc. And this is of course taken care of in the SIEF agreement. I'm just SIEF agreement as. So indeed, when you itemize, when you collect costs, you need to provide full transparency. And this is very important for your lead registrants out there going to issue letter of accesses. For both the provisional part and the full part, you need to document all the costs, the cost sharing model very clearly, because this is information that you need to share with the co-registrants. If possible, allocate the costs to the endpoint level as much as possible. In some cases, it's not possible, but and itemize all costs, the data, segregate data and administrative costs. If someone asks for even more breakdown, you need to have this information available. So be ready to provide justifications why certain costs are what they are. And then also you need to have this, as mentioned, the reimbursement scheme defined and communicated clearly. So what this means is that if someone asks, they would, a co-registrant ask for a full breakdown, you may provide this already proactively, but if you have not provided proactively, then if someone asks, you have to provide this cost breakdown, and it has to be very detailed. So therefore, do it as you progress in your lead registrant work, because doing it later on based on memory or confusing files or emails or receipts may be difficult. Just do it, populate this cost sharing. If you have it in Excel like we do, for example, then do it as you go and progress in your endeavors to become or preparing the provisional lead registration and the final full lead registration. So indeed, data and cost need to be shared in a fair, transparent and non-discriminatory way. This is the same as under EU REACH and UK REACH for that matter, but here of course talking about Turkey. So what basically access to the joint submission via the letter of access process again. So what happens in practice is that the lead registrant will communicate with this with the potential member registrants, saying that this is the SIEF agreement. As you remember, we talked about this as at least you have to communicate as part of lead registration nomination process. You need to communicate the concepts in the SIEF agreement. For example, if REACHLaw is the lead, we already communicate the SIEF agreement, because then you have it. There are all the concepts and stuff like that, and it has to be agreed upon before you are eventually then selected as a lead registrant by the majority of the companies intending to register the substance, or who replied in general. So you do this both for partial and full letter of accesses. So you provide this information, then the co-registrant signs these agreements and pays the letter of access, whether it's the partial or the full. And this the fee depends, of course, is it provisional or the full, because in the provisional you saw the endpoint data that was needed, that maybe today costs, if you would have to do it from scratch, would cost 35,000, but maybe if you buy it from an EU data holder, it will cost you 10,000 or 15,000. But those costs will have to be shared between the registrants, who then going forward with this provisional co-registration. And then, of course, type of registration. If it's an intermediate, of course, the costs are less. Full substance, then the higher tonnage bands, own data, etc. Once you are paid, you signed, then the lead registrant provides access to you in the KKS system, and you can go ahead and submit your provisional co-registration and later on the full co-reg by the applicable registration deadline. And typically, this letter of access is, of course, the most expensive component of the whole KKDIK registration process. The provisional KKDIK or this partial law will, of course, be significantly cheaper than the final law. Of course, very case dependent. But let's say if it's a high tonnage band substance, then of course the joint submission is for high tonnage band that needs a lot of data. Then of course proportionally the data required for the provisional lead registration and co-registration through a letter of access is much less, because for the highest tonnage band you then have all the other annexes that need to be satisfied also. Those costs need to be shared. So indeed, if you look at the partial letter of access, so you will should be either directly and indirectly included. I will talk about what this indirectly means, just to make it slightly more complicated. That will contain required data access or rights to refer to the data. And then what other information is included in this letter of access is, of course, information about the boundary composition, identified uses, classification and labeling, etc., that are usually the same for all of these substances, or uses can be a subset. But then for the full letter of access that you do need for the final registration deadline, then of course you will have additional data required to be covered either directly or indirectly. We'll talk about that as mentioned. Then you have the same boundary compositions, classifications, uses, etc. included. But then it's optional to have either the lead registrant submit the chemical safety report on behalf of the joint submission, or in each company individually submit it. So just make sure when you buy a letter of access to understand that A, who's submitting the CSR, chemical safety report. B, do I get a template when I buy a letter of access if I have to submit it myself? If I get a template, it's easy for me to fill in it, likely this template, because it contains most of the information. I just have to include company specific information, then submit it individually. Or worst case, the lead does not include the CSR at all in the scope of the letter of access. This would mean that you would have to do the CSR from scratch, and that is quite the pain. So typically under EU nowadays, and what we see also in Turkey, is that you will actually get a template for the CSR to be individually submitted. That is likely the very most common case. Then you can also just check that you are getting your guidance of safe use covered or not. Under this provisional law, you will get the guidance of safe use included already, because it's there in the requirements. So the lead will submit this information. Then for the full, it could be that the lead says that no, you need to submit it yourself. But this is, we're going slightly ahead of the time, because no one has done this yet. So we'll see what it looks like at the end of the day, so to speak, as we get closer to the provisional lead registration deadline in March next year. So we will be working, of course, at REACHLaw very hard to prepare these provisional lead registrations dossiers so that we can submit them as soon as possible, of course. But then we will find out exactly what it looks like. Some of these slight gray areas are what they look like in the KKS system. Anyway, now we have this, which complicates things further. So now we had split up partial letter of accesses covering this provisional registration part. Then we have the full letter of access covering the actual registration later on by the applicable registration deadline. On top of this, Olesia already slightly touched upon this subject, but didn't go into more details because it's covered here. So indeed, we could have a situation where, for example, we have here a manufacturer who has, in this case, appointed an OR to take care of the lead registration work, or not to taking care of the lead registration, sorry, meaning wanting to join a joint submission. So for the substance X, so they contact the lead registrant and say, hey, they want to buy, for example, the provisional letter of access. Let's say we have here, we have 3 companies who want to buy the provisional letter of access. So it could be that in this case, the lead registrant can only issue a project law because they cannot cover the data in their law because they are not getting the sub-licensing rights from the data. What that means is that the the lead registrant cannot include data in the letter of access that the lead is issuing. Therefore, what that means is that you have a separate project law and then a separate data law that each and every registrants who want to register this substance X as a manufacturer formulator or only representative will need to buy, including the lead registrant. So you can now see that, okay, if this is needed, you need 2 letter of accesses for the provisional part. For the partial law, you will need likely the 2 letter of accesses, a data and a project, also for the full part. And herein comes the sanctions, for example. If this is an EU owner, then they can, if you are sanctioned or your principal as an OR, if you are an OR and your principal is sanctioned, they can say, no, we will not issue the data law. In that case, you will not be able to register your substance. And this is fully possible because these are, for example, in the EU. They can do that, and they must do it as Olesia rightly pointed out. They have to abide by these sanctions. So you can see that if data owners are issuing this data law separately for both the provisional and the final full registration, they have a mechanism for not having to sell it to the registrants. Because if it would come through the lead registrant that is in Turkey, then there is a clash between sanctions and this fair, transparent, and non-discriminatory clauses. So as we are seeing now, we are seeing this setup becoming more and more prevalent and more common, because they have much better control of who uses your data, and they can issue this data not in perpetuity for as many sub-licensing rights as possible, but for each registrant one by one, which probably results in them making a bit more money on the data. So this indeed complicates things, but this is just the nature of the beast. It's just more admin work, but good for you to understand that indeed it could be, to register one substance, you will need to actually buy, at the end of the day, 2 letter of accesses, one for the partial, one for the full, and those letter of accesses need to both contain one data law Annex 7, for example, as the provisional registration, and the project law for the provisional, and then a separate data law for the full registration and separate project law for the full registration. And it could be, of course, that you have several data owners that are owning, submitting, or sorry, selling data individually for certain endpoints. You could have a lot of different data laws. Thankfully, those are quite rare, but I can see that also happening. Just be aware of it. The administrative side of KKDIK is a bit of a monster, to be honest. So it's anyway. So if we look at the data package, this we covered it essentially, but just wanted to highlight it quickly here that what information is sent and received by the lead registrant. So indeed that you get the law data package. So this could be indeed for the partial or the full law, or then the project law, and information that where you can buy the data law from. But then here I've not split it into that granularity, but I'm just saying that of course what the lead communicates is the price, the agreements, and then a separate acceptance letter. For example, accepting the SIEF agreement. Then once it's signed, the letter of access, the lead registrant sends the invoice to the co-registrants, and once that is done and it's paid, and the lead registrant can see that it's been paid. And for example, if we have this split up between project and data law, then proof that the co-registrant has also bought this data law is provided, and only then will, of course, the lead registrant provide access to the joint submission in KKS, in this case for the provisional part, because that is the step where you provide access to the joint submission. And then optionally share as part of the full law later on for the main registration step, and the CSR template in the best case, guidance of safe use, and other supporting information that is needed to prepare co-registrants to prepare their co-regs registration dossiers. So indeed, I will not go into details, but you can, in the way the lead is accepting companies into the joint submission is done in the KKS system. And you will actually, the lead registrant will do this as part of the provisional registration part, because when you submit your provisional registration, you are already a member of the joint submission. Then the question is, what if you don't go ahead with the actual registration? Then there will be a mechanism for removing you from the joint submission by the applicable registration deadline. It's not visible in the system yet, so we will see what that looks like. Indeed, in the SIEF agreement, it could be called a joint registration cooperation agreement, whatever. I just call it the SIEF agreement as mentioned. It should then provide information, insights into this, who has what information is included, what are the costs that will be shared, and the SIEF agreement then with the letter of access provides its access rights to the joint submission. It also defines the participation of the companies in this joint submission session, essentially how to get organized. This we talked about in the previous part 1 webinars. Also formalizes the appointment of the lead registrant, albeit in the, as we saw in part 1 webinar, it already formalizes it from the perspective of the KKDIK regulation when the member, when you do the nomination and you have majority of companies accepting the conditions of the SIEF agreement, and all of that needed to be done by end of this year, as discussed in previous webinars, parts 1 specifically. And also defines the way you are going to communicate. Is there a specific IT platform? Usually not. There could be like REACHLaw's letter of access 360. We'll talk about that in a separate webinar, or typically just by email. And then these sanctions considerations, as became very clear. And in most cases, these are typically bilingual also. You have a Turkish and English language version side by side. So indeed, the SIEF agreement is a key document for cooperating in the joint submission, and it starts already with this joint, with the lead registrant nomination, but becomes very tangible as part of this provisional registration step. So just make sure that it's right. And there will be future costs. You can bet on it. So just be aware of that. I will go through this lead dossier maintenance. I'm not curious, but conscious of time, so I will just speed up a bit. So indeed, as we know, companies will have the obligation to keep dossiers up to date. This also applies to the lead registrant, but also the co-registrants. There can be these spontaneous update requirements, or there could be requirements by the authority. And essentially, if you find out that you need to update your dossier for whatever reason, we'll look at that in the next slide, you can do so, and you should do so spontaneously. This is a legal requirement. But on top of that, there could be also requirements coming from the authorities pertaining to their compliance checks, processes, or substance evaluations, or other related processes. So you need to also be aware that dossiers are not static, they are kept up to date, and you have this responsibility to update this information. So indeed, information that you typically triggers like a spontaneous update is if something changes in your company, compositional changes, information about the production volume, information about users. If you become aware that new information or hazardous properties have become apparent for your substances, for example, your downstream users, your customers say that, hey, this is having some dermatological effect, meaning it itches when it touches my skin, whilst in the safety data sheet it says that it shouldn't be classified in this way. Then you have to take this into account. Of course, changes in the classification and labeling, updates in CSRs. If you need new tests, testing proposals, etc., and very important to know if you get new importers to cover, and this applies specifically to ORs. So if you, as an only representative, need to cover new importers as downstream users under only representation, meaning you're covering them, then you need to include them into the dossier on an ad hoc basis. So you need to keep your dossier up to date. Let's look at some registration communication related topics. This is just one slide, so that comes probably as a relief by now. So what happens after the lead dossier submission, provisional dossier submission, etc.? Of course, you share, of course, the SIEF agreement has already been shared or is being shared as part of companies wanting to join the joint submission through this buying a partial letter of access so that they satisfy these provisional registration requirements, and later on then for the full part. Then also providing information communication about general maintenance management related topics, and of course again this cost sharing, reimbursement, future costs. It's something that is very much interest. I can tell you that money talks. So when it comes to cost sharing, reimbursements, and future costs, people will listen. But this is a very important communication part. Then of course status updates on the joint registration if they are needed, if any updates are needed on the lead dossier. These could require then updates to the co-registration dossiers, not in all cases. And also, of course, if there are any regulatory processes that need to be managed, or if there are any sanctions issues, etc. But it is very important to communicate and keep your members, co-registrants, member registrants, and SIEF members, of course, up to date what's going on. I put that very simply. Just keep them, rather communicate too much than too little. At the moment, unfortunately, it seems like most lead registrants are opting for communicating very little, and that is always confusing. So rather communicate more than less. Okay, we're coming to the end. I think most of you will be slightly relieved. So we will look at the registration action plan. This is just 2 slides. Most of you will probably intuitively know this already. This we discussed in part 1, but very important to get this SIEF agreement and the context thereof accepted. There's a typo. Now I'm always finding this out during the live, but this is live TV. Anyway, get the context of SIEF agreement agreed, at least the points, but typically even better, the whole SIEF agreement during this lead registration selection process that we talked about, so that it covers all these requirements that we have been here regurgitating many times, so I will not go through those anymore. Anyway, itemize each data and administrative costs as far as possible. That's always good. Then you know what's, and keep track, keep a logbook, whatever, so you know what's going on in your project. Because, you know, if you have to go back 10 years in time and see what you did back then, or 9 years or 5 years, time obscures the memory in that sense. So better to keep a good record, and so for future reference also, but also for the purpose of your co-registrants have the right to ask for itemization of the costs. And then, of course, where applicable, provide these final agreements, including the laws, promptly in good time before the applicable registration deadline. So this partial law, our recommendation is to do it by end of May at the latest 2026, so that gives co-registrants 4 months to prepare and submit their provisional co-registration by the end of September deadline. And then, of course, the full letter of access, even 12 months before the applicable registration deadline, so the first registration deadline of the joint submission. Of course, it will not be possible for the first deadline in most cases, but if you can do at least 6 months before, that would be great. Then just keep being aware that the cooperation in the SIEF and in the joint submission, of course, doesn't stop when you have registered your substance. It continues for as long as there is a joint submission, and for you as long as you are the lead. But of course, the workload is significantly smaller. Tackle the sanctions, consider those very important. Keep dossiers up to date. And of course, keep the costs up to date in the sense that you always know what's going on, and the members know what's waiting for them behind the corner. Also know what and anticipate future costs. I mean, we can't see into the future, but you should anticipate this and make it clear for the co-registrants that there will be future costs, and they will have to chip in, otherwise they are not complying with the requirements of fair, transparent, non-discriminatory conditions, because they have to share in the costs of the joint submission. That's why it's a joint submission. And be very active with the communication. This is I mentioned already. And document everything. Record everything. Record keeping is very important. As said, rather overdo than underdo it. So indeed, don't wait. Act now to take the lead registrant position, because all of these things that we've talked in these parts 1, 2, 3, now the last part 3 here today, going on the last minutes, it's a lot of work, as you can see. So why should I or my OR become the lead registrant? I covered this in the previous webinar, so I will not do it here again. Just wanted to say that if you are wondering about the costs, just be aware that because of this provisional registration mechanism, you will actually be able to already get money back as a lead registrant next year, because you will be issuing these partial letter of accesses, regardless of when the final registration deadline is. So very good to keep that in mind. So it's not like you now take the financial hit and maybe in 2030 you get something back. No, you will get something back already starting next year. And of course, if your deadline is the end of next year, then you will get all but your the shareable portions back. Of course, you will also share. You are also responsible to share in the costs, but still, it will be like you would buy a letter of access, also the same costs, more or less. Yes, put simply, nominate yourself as the lead registrant for the substances that do not yet have a lead registrant. Very important. Time is short. Do it now. Better safe than sorry. As said, you can relinquish your lead registrant position later on if you don't want to be a lead for the full registration part, provided those deadlines are then in 28th or 30. Conclusions, very quickly. The registration phase has started because of this procedures and principles document. So the first thing that's coming up ahead is, of course, the provisional lead registration deadline end of March. So it's coming up very quickly. Before that, of course, we had our lead registrant selection deadline we talked about in previous parts. So have a look at those. Start the joint registration work as a lead registrant as soon as possible. That is clear. Know that all the data and costs need to be shared in a fair, transparent, and discriminatory way, as we discussed in quite a lot of detail here already. And take care of these lead registrant obligations. This includes the communication and maintaining and keeping things up to date, including the dossier. And for sanctions, of course, these are legal requirements under EU sanctions law, and these clauses become standards and necessary elements of KKDIK agreement. So you have to navigate these, and it's not optional, as Olesia already mentioned. And also, just for you to remember basics, non-Turkish manufacturers, formulators can choose a professional only representative in Turkey to take care of these KKDIK obligations, including all the work we've discussed here as the lead registrant. And we at REACHLaw, we're of course very happy to do that through our office in Turkey. So indeed, please feel free to reach out to us, ask for quotation, any help you need, just feel free to contact us at sales@reachlaw.fi. And now we go to the Q&A, and you get to hear again my colleagues a bit more. So I will take just these, we only have a few questions here. I see that there's a lot of questions in the chat. Oh dear, that's a lot of questions. Okay, we'll take a few. I know we've gone on for 2 hours already. This will be the longest. Apologies for that. Complicated topics. Anyway, are you there, Olesia and Sibel? Ready to answer questions?
Yes, yes.
Yes, still awake. Good.
Yes.
A bit of banter there. Anyway, so we'll start with this question that came from the previous webinar. So indeed, I promised we would cover it here. So now that we have Olesia on the line, I will just read out the question, and you will get to answer this one. And actually, I'll take the other question, which is essentially the same in the same go. So bear with me. So the question number 1 on sanctions is that as a non-Turkish organization, we are obligated to comply with EU-US sanctions against Russia. How is this compatible with work in the SIEF when some companies are represented by an OR and not obligated to share their identity? So this was a previous webinar, and I'll add question 4 in here because it's the same essentially. And question 4 is, as a non-Turkish organization, we are obligated to comply. Oh, this is probably exactly the same question. Yes. Oh, it is the same question. Okay, so I will not read it again. Olesia, what's your answer?
Yes, well, that's as you have seen from our slides, and this was only part of the examples of possible compliance programs and due diligence. For sanctions compliance, it's not very simple. In fact, it is very complex. And yes, you need to comply with EU sanctions regulations and US economic sanctions regulations if you are linked to those jurisdictions and have obligations under those. And you also want to comply with Turkish KKDIK. You need to work in the SIEF, as you said, indeed. But as we have explained, you can design a due diligence program in a way that you would not only do your best. As you remember, it's not enough under the sanctions regulations because you have the application of result, meaning you have to absolutely not make any economic funds or resources available to sanctioned persons or entities, and data, the EU REACH data is considered such potentially economic fund or benefit. So what you could do, you could implement, first of all, sanctions clauses in the agreements, so in the SIEF agreements, and make them absolutely visible. So don't hide them somewhere in the middle of the agreement. So make them, as in the example we have shown, a separate article in the agreement, and also in the signature page if you have it separately, or in the signature section, again, as a reminder that you can only sign this if you certify that you are not sanctioned, neither is your represented company if you're a third-party representative or an only representative. Then you can also separately request the signature of the so-called declarations of compliance or sanctions compliance certificate, where you would list all the requirements that you would want a co-registrant to fulfill. And you could also request what is done in the EU. You could request not only the OR to sign, but also a represented company to sign. So you could try to implement this process in the KKDIK as well. But I must tell you that from our experience, at least at the moment, we mostly see that the certificates of compliance with sanctions are being requested to be signed by the only representatives. And when you sign that, you also confirm that you have checked the compliance with sanctions from your represented company. So it's shifting of the responsibility from one party to another, essentially, but it's not circumvention. So it could be justified in your due diligence program. So it's the matter of the due diligence program that would be calibrated according to the needs of your business and should be proportional in terms of its applicability and, like, you know, in the current reality. So I'm sorry I cannot give you much more information, but I think I have given some tips and hints on how it is possible to organize internally. Thank you.
Thank you. Thank you, Olesia. And if someone comes and asks that they are sanctioned and asks us, for example, for help, we cannot say anything to them. Cannot even help them, and of course you probably would not even want to help, but just to show that we can't really do anything on that front. So don't even ask if you are such a case. But anyway, let's go forward. Thank you, Olesia. Question number 2: what triggers the obligation? This is for you, Sibel. What triggers the obligations for joint registrant to submit the provisional registration, and what will be the role of the lead registrant? And actually, Sibel, I will take this because we've covered this now to nausea already in these three webinars. So I invite you to just have a look at this recordings specifically in part 2. So I think this has already been covered in this webinar webinar series, at least enough. So sorry to cut you there, Sibel, but I'll take you to the next question. So what principles will be used by the ministry when allocating leads to substances where lead registrant has not yet been agreed? I mean, for example, is the highest tonnage ban, most data already a lead for other joint submission, etc. So Sibel, please.
Yes, thank you, Frederik. Here I can shortly say that according to the procedure and principle document, criteria such as the tonnage band, existing data, and the company size will be taken into account when deciding for this.
Yeah, and it doesn't necessarily have to be the one that has the highest tonnage band, etc. But it's several criteria.
Yes.
Good. Yeah. Next question: is it necessary to obtain a right to refer to prepare the provisional registration dossier? I'll take this one, Sibel, because we discussed this already. Just revisit this webinar, this letter of access part, where we looked at this data that is used under this provisional lead registration dossier. So as we see it now, yes, you will need you need to obtain this, which means if you are a co-registrant, you need to buy a letter of access. Or if you lead, then you can negotiate with the data owner to accept these, buy this data for sub-licensing rights. Or then we have this hybrid case where you buy a project law for this for the provisional registration, and then the data separately. But to answer simply, yes, to number 5. And then number 6, Sibel, what will happen if a company wants to pre-register a new substance after September 30th next year, 26? If the lead registrant has submitted the provisional registration, does the co-registrant need to submit the provisional co-registration quickly after pre-registration? If you elaborate a bit on that, Sibel.
Yes, Frederik. Here, maybe to just also to cover the process, saying that substances imported at 1 ton or more per year have to be first pre-registered, then registered according to the KKDIK regulation requirements. If you see your substance will be increasing 1 ton or more per year after September 30, 2026, you have to start to prepare the registration related practicalities actually for your substance. But considering your question to say substance first time imported to Turkish market after publication of PNP documents, should this company should submit their pre-registration in 30 days and become a SIEF member. Then yes, you have to first pre-register and become a SIEF member. Then if there is a provisional co-register, if there is a provisional registration by the lead registrant, then you have to afterwards in a short period have to submit your provisional co-registration. And then also we can say you can only import at 1 ton or more once you receive your registration number.
Thank you, Sibel. Very good. I can see that we have so many questions here in the chat. I would just take a few in the interest of saving a few minutes, which we've gone over time already quite significantly, but I can take it here like, can you please explain the significance of being a lead registrant? Are there additional cost, additional workload, additional benefits? I mean, benefits are, it's the slide I skipped, so I invite you to go back and look at part 2 on YouTube, but essentially, of course, as a lead, you're in control of the process, you know what's happening, then you can rely that they will be registered. I assume you are interested in getting the substance registered, because the worst case I would see is that if, for example, someone who really is not up to the job is appointed or recommended to be appointed by this TOBB and the ministry, then I see quite a lot of risks in that process. So that is a benefit. Risk management is a benefit. Will there be additional costs? Well, all costs that go to the joint submission of the substance can be shared, and also your work as the lead registrant are costs that can be shared. This has to be, of course, reasonable, but yes, essentially there are not additional costs per se. Of course, you will likely in the beginning have to put up a bit more money to get the ball rolling, but as said, you will get money back already next year as part of these provisional, these partial letter of accesses. So, I mean, at this point in time, when the uncertainty is that there is no lead registrant and what happens with the substance, then I see there's only being upside at this point in time to become the lead registrant, because you will get money back. It's a bit of an effort, but just be sure that REACHLaw, for example, is happy to help you with the lead registration work. We will do all the practical work. You just have to provide us a bit of information and essentially get the project up and running, meaning ask for a quotation, for example, and sign an agreement, and then we get started with that. And of course, get yourself nominated, appointed as the lead registrant. Quick question, is it possible to skip provisional registration and go directly to full registration? No, at this point in time. I mean, if you as a lead now would lead register by end of March, submit the full dossier, then of course a provisional registration is not required. If there is a full law available when you, for example, for the first time start registering a substance, it could be that you could actually then not have to, as a co-registrant, go through the provisional, but go directly to a full registration. But that actually needs to be confirmed. But I assume that would be possible, because provisional is just provisional. You're just submitting a subset of the information. Why not, if it's possible later down the line for a co-registrant for a new case, if they want to register immediately for the first time, then I don't see a problem with that. But we can check that, and it's a bit down the line still yet. Let's see if I can find one question. Yeah, here's one for you, Olesia. Well, you answered this already, but let's reiterate. Does the sanctions mean that we, EU-based company, cannot share any data or joint submission with Russian companies or Russian ORs in Turkey? So the answer is yes, but if you want to elaborate.
Well, it's there is a ban for consultancy under the Article 5N and other services for the Russia-based companies. However, like Russian company in general, just being Russia-based doesn't mean that it's sanctioned.
Yeah,
so you need to verify if it's sanctioned based on the ownership, control, and well, there are many implications. So you would need to, you would need to really kind of verify if it's really a sanctioned entity. And many companies take the cautious approach, and then they assume that if the company is located in Russia, in the regime that Russia currently has, that it could be controlled by potentially by Russian state. So there are many different approaches here. So there is no answer to your question, but it just requires a lot of investigation from your side if you really want to proceed with those negotiations.
Indeed, very good point. And this is the last question because it's an easy one. The rest of the questions, as I did, I think, soft promise is to make this Q&A document. We would then include these questions also, but please be patient with that. We're very busy, so and we will only share the Q&A with the companies who actually attended this webinar and stayed to the end. No, who attended, that's enough. So last question. Who must sign a SIEF agreement, the OR or the non-Turkish company appointing the OR? So it is the only representative, because they are the one who are the legal entity in Turkey under the KKDIK regulation. So it's always the OR who is the registration holder on behalf of the non-Turkish based company. But you can change always ORs. So the answer is only representative. Yeah. I'll just leave it at that. Sorry for not being able to take more questions, but as I said, we'll return with the Q&A. Just give us some time with that. Thank you. So with that, feel free to reach out to us to help with multitude of questions, including sanctions. Now Olesia is pulling her hair, but nonetheless, if you have any questions on that, please do feel free to reach out to us. We're happy to help. And I said, with that, I congratulate you for completing the curriculum. So congrats to you, and thank you very much for your attention and staying to the end. And of course, thank you to my colleagues, Sibel and Olesia, for your input. And of course, the biggest thank you go out to all of you attendees who attended our webinar series, this webinar today, and stayed till the end. You are rock stars. Thank you very much, and I wish you a great day. Bye-bye.